Okay, so we're ready for the home stretch here. This is our final panel today in the new landscape in context, immigration adjudication. So all day we've been talking about this new landscape in administrative law, and now we're going to dive into a very specific context. As I was looking at the lovely map that was up there earlier, that's now been taken down, the old-fashioned map with the new landscape, I kept thinking that it needed some place on it that said, "Here be dragons." So this is it. We have a very distinguished panel, and I want to just very briefly introduce them to you. Our first panelist is going to be Michael Kagan, who is the Joyce Mack Professor of Law and Director of the Immigration Clinic at the University of Nevada, Las Vegas. In addition to directing that clinic, he teaches administrative law, professional responsibility, international and human rights, and immigration law. And before going to the University of Nevada, Professor Kagan spent 10 years building legal aid programs for refugees throughout the Middle East and Asia. And he lived in London, Cairo, Beirut, and Jerusalem, and held teaching positions at Tel Aviv University and the American University in Cairo. Our next speaker will be Catherine Yong Soo Kim, who is professor of law at Brooklyn Law School. And I say that with some sadness because she was at UNC for many years. Welcome back. It's good to have you back in North Carolina. Professor Kim teaches immigration law, administrative law, anti-discrimination law, and civil procedure. Prior to joining UNC Law School several years ago, she was staff attorney at the ACLU Union Foundation, where she litigated a range of cases related to government policies enacted post 9/11, the school-to-prison pipeline, and education rights of Native American children. Her co-author, who will be presenting a paper with her, is Amy Semet, who's a lecturer in quantitative social science and political science at Columbia University. And I just found out she is joining the faculty at SUNY Buffalo next fall, so congratulations on the new faculty position. Dr. Semet's research focuses on institutional development of American government and in applying quantitative techniques to the study of legal issues in intellectual property and administrative law. And then finally, we will hear a paper from Jennifer Koh, professor of law and director of the Immigration Clinic at Western State College of Law. Before entering law teaching, Professor Koh was an associate at the law firm of Wilmer Cutler, Pickering & Hale, and where she represented corporate and individual clients in litigation, government investigations, and international arbitration. And she was also the director of the Community Liaison Project for Sanctuary for Families Center for Battered Women's Legal Services in New York City. So we have decided to structure this panel as follows. Professor Kagan is going to give us an overview of immigration adjudication and some recent critiques of immigration adjudication. So this will build nicely off the last panel of administrative judges. And then we will hear the two papers, first from Professor Kim and Dr. Semet, and then from Professor Koh, and then we should have some time left for a robust discussion with all of you. So take it away, Professor Kagan.
Thank you. Okay, let me just start. I don't want to spend too much time on thank yous, but I do really want to thank the Duke Law Journal. It's been an amazingly stimulating symposium so far, and I hope you'll find, I certainly think that a lot of the themes that we've already heard, definitely in the lunchtime presentation, but in all of the panels, I think lead up to this one really, really well. I want to thank Chris Walker for inviting me to be part of this, and given that I didn't even write a paper. So so it's great. It's really great. And finally, Jennifer Koh, who lent me a couple of the slides I'm using. So among other things. So the topic here, I practiced in immigration court in Las Vegas primarily, and at the BIA, and in the Ninth Circuit Court of Appeals, and on these cases. And I'm going to be focused on critiques. I want to say not everything goes badly. We had a merits hearing last week. I don't know if I'll agree with the decision or not, but it was a very good hearing. I think what you want in a hearing, and I think my student had a good experience. And I think DHS counsel probably for that too, but I can't go too far into details like that. I am going to focus on critiques. I have put the word some underlined because certainly probably not going to cover everything. We could spend several days of a symposium just on immigration adjudication and go into far more detail. This is a very, very hot issue now. It's not really new. It did not start in 2017, but it is definitely brewing. You can see this in the place that immigration courts and immigration court reform have in presidential platforms of leading candidates right now. Just yesterday, I'm reading from the NPR website, Senate Democrats accuse Justice Department of politicizing immigration courts. So this is something that's very much and had moved really up on the agenda. It probably isn't going to go away anytime soon. Here's kind of the major issues I'm going to try to highlight, really in brief terms. First of all, high volume and high stakes. That's really characteristic of the immigration courts. I'll go into that. Resources and backlog, that obviously relates to the high volume. The limited jurisdiction of immigration courts. I will pitch to you my shtick on immigration courts is that it's not a good name for what they are. Even if this body functions well or not, first of all, they're not really courts, as we're talking about. They really should be called something more like a board or tribunal, because it is in the administrative realm. Secondly, they're not about immigration. I'll come back to what I mean by that. I'm not trying to be too cute with that words, but I'll explain what I mean in a moment. And then the big issues, like the one from, the headline from yesterday, have to do with independence, but I will divide that into two different sectors. Independence about the law, and then independence on the managerial side, both of which are really hot right now, but I think they're often intermingled. Okay, so this is probably one of the pithiest quotes that you'll hear, and it gets repeated over and over again from Judge Dana Lee Marks. We're doing death penalty cases in traffic court setting. Essentially, that is emphasizing the high stakes, high volume problem. So here's what the high stakes means. Basically every case in the immigration court is about deportation. So somebody is here in the U.S., although actually with the MPP program, that's now become more complicated. But and the question is whether they'll be ordered removed from the country. So technically, we don't deport people, we remove them. Immigration courts deal with detention. So I have learned the hard way through conferences not to say that the stakes in immigration cases are higher than in other areas of administrative law. Obviously, a great deal is at stake in Medicaid cases, a great deal at stake in veterans benefits cases and in patent cases. But it is pretty rare in the administrative setting for people to be in shackles and for people to be coming from a detention center on video screen. That has a lot more in common with a criminal court. And but of course, it is in the civil domain without the much more elaborate protections that come from in a criminal setting. So that is really very much the background for many of critiques about immigration adjudication. In addition to the fact that people are locked up and immigration judges do bond hearings, for example, to set bond, they deal with asylum. So people's physical safety is at issue in coming to the right decision on whether they would be persecuted or tortured in a foreign country. And then there are a whole bunch of other issues in immigration cases, in immigration court, but they're often dealing with the question of whether a family should be broken up, because that's what often deportation means. So the stakes here just could not really be higher for individuals, and in this case for individuals who almost always have almost no resources. So that lack of counsel is a real big issue. About 3/4, in Las Vegas, 3/4 of people in detention don't have lawyers. So that's also quite different, obviously, from the way it would play out in a criminal context. So this one, I have to give verbal footnotes since I didn't put them. This is from the EOIR website. This is recent filings and completions. I'm going to show you a line graph also from their website in a moment about this. But basically, if you look in the left-hand column, 2019, Director McHenry just referred to this, 500,000 initial receipts of new cases in the immigration courts, and so that's per month 42,000. It's really, really, really big. And you can go back, it was considerably lower. This is what we just heard about, 16,000 in 2015, quite a bit lower than 42,000 per month. So that's the ebb and flow of new cases coming in. That's the quantity. And that has led to a corresponding increase in case backlogs, which last year topped 1 million. Okay. Now, here's what I mean by the limited jurisdiction. A second. So, immigration court hears removal proceeding cases. So the issue is always about removing someone from the United States. Now, that could be a recent arrival, or it could be someone who's been here for 20 years. But it's fundamentally removal proceedings. And courts adjudicate everything for legal permanent resident. Is this a type of criminal conviction that would make you removable? To what kind of hardship will your family suffer if you were deported? That's cancellation of removal. Asylum cases, and a whole bunch of other things in between. But the immigration courts don't do actually much about immigration. So if someone is denied a visa, this is not where you go. And the other important thing about the limited jurisdiction, and it really lies behind many of the disputes today about some recent changes in the immigration court, is that when someone is in the United States, but the Department of Homeland Security would like to remove them from the United States, the immigration courts don't always have jurisdiction over many of the issues most pertinent to whether they can stay. So, for example, if I am in removal proceedings and I am married to someone who can sponsor me, and I think I can get a visa, I have to submit something called an I-130 to USCIS and have that adjudicated before I could adjust my status. And USCIS has its own backlogs and its own adjudication, which we don't have a panel on, but we could have, where for that form, depending on the details, that can take, according to the website I just checked it today, between 12 and a half to 26 months to adjudicate. So what that means in immigration court is there's a removal proceeding against me going forward. At the same time, I might be applying for a visa. The immigration judge can see in front of them that this person is probably eligible or not for that visa, but actually can't adjudicate the fundamental matter. That is where some issues that have come up, which I'll get to in a moment, like continuances become very important, because you basically, the immigration court doesn't even have jurisdiction over all the immigration issues affecting that person. And that's a really important, there are other examples besides the I-130. If you go and sit and watch master calendar hearings at an immigration court, which I encourage people to do, you will probably hear this discussed, particularly on a non-detained docket. People talking about, well, I filed this with USCIS, I filed that with USCIS, and people throwing their hands up about, well, when are we going to hear on that, and what do we do with the removal case? So you kind of end up with a race of two trains on two different tracks, and you can get somebody removed, ordered removed, and then a few months later have them actually granted a visa. And it doesn't seem like the way most people would probably set up the system, but it is the way we have that. That's one of the reasons, again, why I would say these courts are not about immigration. They're removal courts that have jurisdiction over certain limited forms of relief from removal. Even asylum is really structured as essentially an affirmative defense to removal. So the respondent bears the burden of proof there, like an affirmative defense. But these are removal cases here. Director McHenry referred to this. We don't have time to go into it, but a very big concern that has been raised for years about immigration courts is inconsistency. There's a famous book about this called Refugee Roulette, which, as a UNLV professor, I have to note has a great Nevada name, although it's not actually based in Nevada at all. But basically the point is that it is better to select the judge than to select the law. And there seems to be, certainly as a practitioner, I know that I see cases that Las Vegas actually has statistically is one of the hardest places in the country to win asylum. And I will see decisions from immigration courts in other places, and I'll think, wow, that seems a lot weaker than the case I just lost last week. And these statistics back up that sentiment. I know that there's debate about that, but you can see these New York judges, those are denial rates in the lower right-hand corner. And then Charlotte, probably of most interest locally, also does not look like a great place to apply for asylum. Much better to apply in New York, as you can see there, just statistically. Now, I refer you to the book and to others. A great deal has been written about this to look at the details. It has been compared at least nationality to nationality. Of course, it's possible and likely, actually, that different immigration courts will get different types of cases. So you would not expect even the same judge to reach the same decisions everywhere, but this is a pretty well-documented field of inconsistency. Now, this is the kind of structure of immigration adjudication chart I would show students in terms of this is how it works in a removal proceeding. DHS starts the proceeding in immigration court, then that can be appealed to the BIA, that's also within EOIR, and very importantly, and having really increasing importance in the Trump administration, the Attorney General sits atop there, and it's as a tertiary appeal. And the Attorney General, you can easily, most of the time, forget that he's even there. But he has the authority to take a case and refer it to himself. And the circuit courts are on top of that, and that's a whole other complexity because they have even more limited jurisdiction. The AG's role, you have Trump Attorney Generals have issued decisions limiting substantive eligibility for asylum. Also, with Attorney General Sessions, he gave actually 2 speeches, but the most famous is the what's known as the dirty immigration lawyer speech, referring to immigrant defense attorneys. And he gave that speech to new immigration judges. And while that kind of rhetoric is probably normal in the political arena, it's very difficult to imagine, say, Chief Justice Roberts giving a speech to new federal magistrate judges and referring to criminal defense lawyers that way. And that raises whether, I will leave it to others to decide whether that is itself a due process violation, but it's certainly a breach of a kind of decorum. This was a presidential decision issued by the Attorney General, and these decisions are issued with adversarial briefing. And this one was about the end of administrative closure. So that was one of the mechanisms immigration judges had used to manage those 2 trains and to prevent one from reaching the destination for the other. Administrative closure has now been ended, except in the 4th Circuit, I think. Then we get to another issue, which is, are they judges or are they employees? We've already heard a lot about that. And I found this interesting. This is also on the EOIR website, the organizational chart. The top box is sitting in the back corner. What I find interesting about this is it's so different from the structure of the adjudication that I just showed you, that you can see the Board of Immigration Appeals is over on the left, the chief immigration judge is there in the middle, all kind of flat. And I think that reflects something else that's really important that's gone on, which is that there's also a lot going on that's not coming through appellate litigation. So it's not coming through a precedent decision from the BIA or the AG. But you have, say, for example, this is a memorandum from the chief immigration judge about unaccompanied children. And if you read the full memorandum, there's a lot of procedural, but also some substantive law in this memorandum. And there are a lot of others like this. And those are not being sent through an appellate system. Those are being sent through essentially through like a hierarchy. It's like a memo you get from your boss is what it looks like. There are these performance metrics about quantity of cases to complete. And again, that quantity issue, especially when you have the potential of that there's another process independent of the court that might allow someone to stay in the US, finishing cases faster, it becomes much more problematic because of that. But against that also becomes that debate about does that impair independence of the judge. And finally, this is I think it's what Director McHenry was referring to, that progress has been made, at least in terms of quantity of decisions, in terms of how many decisions are getting made, both through having more judges. I wanted to note one last closing thing. I'm probably well over time, but in addition to about resources, I'm glad in the last panel there was a discussion of clerks as well. I think that's also important about the complexity of these cases, that the judges need decision-making support. And so in Las Vegas, I believe there's 2 clerks for 5 judges. Now, I understand from a conversation I just had with Director McHenry that it's quite complicated. I won't get into in terms of what it would take to give immigration judges the kind of clerk support that the stakes and complexity of their cases probably deserve. I'll leave that for another time, but that is another area where the system shows a lot of cracks, I would say. So thank you very much for letting me go a couple minutes over.
So I am going to talk about a project that my co-author Amy, Semet, and I are working on. And I'll just give some background and framing. I'll turn it over to Amy to talk about the actual findings, and then I'll close it out with some closing thoughts about the project. So, but before I do that, I want to thank Chris and Emily and Kent and the editors of the Duke Law Journal for organizing this fantastic event and for inviting us to participate. It's been great. So this particular project undertakes an empirical study of about 610,000 immigration judge custody decisions in immigration courts between 2001 and 2019. And we're trying to measure to the best we can the extent to which these custody decisions may be susceptible to influence by the political preferences of a presidential administration rather than, for example, an independent assessment of the record evidence. And it follows from an earlier project that will just be coming out in print at the end of this month, in which we examined political trends in immigration decisions relating to the ultimate decision to deport. In that project, we found evidence consistent with the premise that presidential administrations are able to exercise influence over immigration adjudications. We found, for example, that after controlling for over a dozen control variables that would theoretically impact the decision to deport, the same cohort of judges was 22% less likely to deport an individual during the Bush II or Obama administrations than during the Trump administration. So again, that's after controlling for a dozen other variables, such as the individual's judge, et cetera. So this project shifts the focus from the ultimate decision to deport to the preliminary decision of whether to detain pending deportation proceedings. So, as has been noted, the immigration courts currently have a backlog of over 1 million cases. And so that means that these removal cases are taking up to several years to resolve. So for the individual non-citizen, a crucial question is going to be whether they're going to be detained pending the outcome of those removal proceedings. And so in immigration judges, we've heard, are non-ALJ adjudicators who preside over the proceedings in immigration courts. They preside over both the deportation decision as well as the detention decision. And the immigration court proceedings are not governed by the APA, but they are formal evidentiary hearings and have a lot of the bells and whistles we associate with a regular trial-type hearing. Cross-examination, right to private counsel, etc. But as we've heard, immigration judges lack the more robust tenure protections of ALJs and are explicitly appointed by the Attorney General and are subject to the supervision of the Attorney General. Currently, I think we heard there are about 450, 460 IJs in around 60 to 70 immigration courts around the country. So again, these judges, these adjudicators are deciding both whether to ultimately deport the individual as well as whether, in some cases, they're going to be detained pending the removal decision. So the U.S. immigration detention system constitutes the single largest system of incarceration in the United States. On any given day, up to 47,000 individuals are being detained in immigrant detention, and in a given year, it'll be almost 500,000 are going to be detained. Many of these facilities are operated by state and local jails and prisons, as well as by private prison contractors. And the conditions in these facilities, including the restrictions on access to counsel, limitations on family visits, substandard hygiene, substandard medical care, et cetera. These have been pretty well documented, including by the government itself. Pursuant to congressional legislation, the detention for many non-citizens accused of being deportable is mandatory. That is, nobody has any discretion, including the immigration judges, to release them from detention pending removal proceedings. But for others, detention is discretionary. And in the first instance, that discretion is going to be exercised by the enforcement officials of Immigration and Customs Enforcement, who have the authority to release the individual on recognizance or grant conditional parole, release them on bond of at least $1,500, or deny bond altogether. For those individuals who remain detained after that initial ICE enforcement decision, they have a right to a bond redetermination hearing once they're in immigration court. At that point, the immigration judge, again, the non-ALJ adjudicator, also has the authority to release on recognizance, grant bond so long as it's over $1,500, or deny bond altogether. And so a lot of folks debate the extent to which the decisions of enforcement officials should be subject to political control. But I think that the extent to which adjudicative individuals are subject to political control is a lot more controversial. So I think most administrative law scholars have assumed that that agency adjudicators are insulated from political influence. And so we are really looking to see whether that is borne out by the empirical evidence. Again, our earlier empirical study on deportation decisions suggests that maybe adjudicators are not so insulated from the political preferences of the administration. And at least anecdotal reports had suggested the same was true for immigrant detention decisions. Immigration practitioners, for example, have complained that IJs under the Trump administration were routinely denying bond altogether or setting them at unrealistically high amounts of $10,000 or more, while according to these anecdotal reports, whereas these IJs under the Obama administration were routinely releasing these individuals on no bond. So this project takes an empirical look at IJ custody decisions to see whether these anecdotal reports are borne out by the evidence. So I'll turn it over to my co-author to talk about our findings.
Yeah, I'll talk first about our database. RI is a really great agency in that they have presented on their website a database of all their removal decisions in all immigration cases going back to 1951, including about 60 CSV files where you could look at detention decisions, you can look at juvenile decisions, whatever. So over the course of these two projects, we built the database to combine the various files to be able to understand how the courts are making decisions. So in this particular project, we limit our focus to only the bond decisions. From the particular from doing the Bush 2 administrations through the mid part of the Trump administration, so from January 20th, 2001 through September 30th of this year, decided by IJs that are appointed. Some cases are heard by people who are visitors or IJs that are not appointed, so we limit to people who would be appointed. Sometimes there would be multiple bond decisions. We would limit our analysis to the first bond decision. Now, there's various types of cases we excluded. We excluded juvenile cases, rider cases, because those type of considerations might be different than if you have dependents or juveniles, the determination of bond might be somewhat different. We limit our analysis to removal cases only. We excluded cases dealing with about 2% of immigration court cases involve other issues other than removal, so we didn't include those decisions. We limit our analysis to decisions decided by appointees after Reagan through Trump, because we had more cases to deal with that. And we also limited to judges who had decided at least 50 bond proceedings over the time period of our study, as well as cases in which and then we also limit cases in which the custody status is never detained. So, in our, this is how there's a variable in the bond database about what the bond decision. So there's a coded a few different ways. So it can be coded as you're released from your own recognizance, you recode as a new bond amount, and you'd be able to determine if the bond amount is higher or lower, because there's another variable that gives the initial bond amount that was set by ICE, and then a new bond amount that would be set by the IJ. The problem with the data is that this information is often missing. So some judges input the data, some judges do not. So that creates somewhat of a problem with respect to analyzing the data. No changes, another option, no action, no bond, and no jurisdiction. In this analysis, we eliminate the cases that had no jurisdiction as a decision. And then we calculate what would be the win rate. So one, if someone was released from their own recognizance, or if they had a lower bond amount, then was that set by ICE, and 0 if it was one of the other options. Like I mentioned, there's much missing data with respect to the initial and new bond amounts, especially going back in prior years. It's going back prior to 2007, or I used a different database, so some of the data is not as thorough as more current data. So our analysis is simply limited to a descriptive bivariate analysis in the graphs I'm going to show you. So this one here shows the win rates, and you can see by color I have we have the non-citizen win rate, and the different colors represent who appointed the given IJ. And you see that generally, this is over the whole time period. So you see generally there, although it doesn't look much different, there are statistically significant differences between some of the judges, and you see that the Obama judges have the highest win rate, meaning that they were more likely to release non-citizens on recognizance or lower their bond amounts than appointees of other judges. The next slide deals with the decision of no bond, so the decision of no bond versus one of the other decisions. And you see here again, we see a similar pattern with respect to Obama-appointed judges having a different numbers. Then we looked at the rates also by presidential era. So this is all appointees, whether it be the Trump era, the Obama era, and the Bush era. Generally, it's the case that during the Bush era, the rates of no recognizance were different than they would be compared to the Trump and Obama era. And we can see here that the rates are different based on the eras. Next slide looks at the no bond, the no bond decision based on, you can see here that the Trump era has a statistically significant difference with respect to no bond decisions being made. Then we looked at also by appointee cohort and presidential era. And you see here, this is where you see, I think, probably the most clarity with respect to the decision making. You see here that in the Trump era, you see that Reagan So it's surprising to some extent that some of the appointees of earlier presidents have lower win rates than some of the appointees of Trump or Obama. The next slide, and then we next get into looking at bond amounts and percentages by presidential era. So we looked at, we characterized bonds as low bond, medium bond, or high bond. A low bond was something $25,000 or less, medium bond was in between, and a high bond was $10,000 or more. And we see the bond amounts by presidential era. And you can see here that the percentages that are the high bond are much higher in the Trump era. Now, in the next slide, we look at these amounts, just looking at the low bond amounts. And we see here that the low bond amounts, if you just compare the Trump era and the Bush era, there's much higher low bond amounts in the Bush era. And then finally, the next one, we look at this is high bond amounts, and you see the high bond amounts are much higher in the Trump era. Now, like I mentioned, this analysis has various limitations. Like what I presented was just descriptive bivariate analysis. The refugee roulette, the seminal study on that kind of started this empirical look at administrative adjudication, they too did a lot of bivariate analysis with respect to see that there were statistically significant differences among courts with respect to some of their decision making. So bivariate analysis it helps you discern patterns to see what you may go further explore. Now, the limitations of this analysis, of course, is the data quality. There's a lot of missing data. You might have to impute data. The data is somewhat inconsistent over time, periods of time. And like I said, it's a bivariate analysis. In our other analysis dealing with the removal decisions generally, we included a lot more controls about the non-immigrant, whether they had a lawyer, what country they were from, the language, the nationality, whether it was an asylum case, whether they came from a poor country, the more features of the IJ themselves, whether they were female, whether their prior experience or tenure, geographic features of the IJ's home-based city, such as the unemployment rate or whether there was a large increase in the foreign-born, as well as institutional variables like Congress, circuit courts, and the BIA, as well as year. So another problem with this analysis is that some information is just not going to be, you aren't able to get some of the information. Like ideally, we would know a lot more about the people's family situations because of various privacy concerns and whatnot. You don't know the people's gender, whether they've been long-term permanent residents, whether they have juveniles isn't necessarily reliably coded. And then finally, the last thing is selection effects. As Catherine mentioned, the IJ is not necessarily coming at the bond amounts on their own. Their bond amounts are set by ICE initially, and then they fire off for a bond redetermination hearing. So the amount can be somewhat based on how ICE would be behaving. So I'll turn it to Catherine to close up with some remaining comments.
I guess I would just, to tie this together to some of the larger themes throughout the symposium today is, our findings both in this project and in our previous one suggesting that the same cohorts of agency adjudicators are deciding cases differently depending on who's in control of the White House at a given time. I think that this, though, raises a larger normative tension on the extent to which agency adjudicators should be independent, right, with values of individual due process interests, the independence noted by Chief Judge Griswold and talked about by Kent, weighed against the need for things like uniformity, avoiding the heterogeneity identified by Melissa and Michael, and the need for professionalism. And I think that question of how to balance that tension between sort of supervisory control versus adjudicative independence is a $64,000 question that we keep coming back to. And so I guess our project just sort of looks at that, but I hope that it opens up this dialogue on that underlying normative theme.
Thank you. So if we are now in the land of dragons, I'd like to pull us yet even further deeper under the water. And what I'd like to do is actually shift our focus away from immigration courts that, Mike already gave us this really great view of, and that I'll just highlight to you one quote from a recent American Bar Association Commission on Immigration study. One thing that they reported on their characterization of the immigration courts was as irredeemably dysfunctional and on the brink of collapse. But again, I actually want to shift our focus away from the immigration courts and judges themselves, and instead situate my presentation today within some of my broader work on what I call shadow removals, or removal orders that are issued outside of the immigration courts altogether, generally by frontline officers employed by Customs and Border Protection or Immigration and Customs Enforcement, or ICE, or in a manner where even if an immigration judge is issuing that order, the adjudication is really peripheral to the immigration court itself. Maybe there's some kind of IJ review, but it actually involves really minimal substantive engagement with the merits of the case. And so there are a number of different types of removal orders that fall within this broader category of shadow removals that I talk about in other work. But I will share with you one statistic, which is that in recent years, upwards of 83 to 85% of all orders of removal issued by the federal government actually fall within just actually the first two of these categories, what's known as expedited removal, typically used for people at the border, and reinstatement of removal for people who have been previously or been ordered removed by the government. Oh dear, my notes have disappeared a little bit. Oh, okay, and so in that prior work, I make just a couple of arguments that I'll share with you. One is that to the extent that we do believe that there are structural deficiencies in the immigration courts, things like decisional disparities or the oversimplification of legal claims resulting in part from the confluence of detention, time pressure, and the absence of government-appointed counsel, to the extent we have concerns about institutional competence or decisional independence or a lack of accountability resulting from various statutory restrictions on judicial review, well, it's actually much worse when we're talking about shadow removals, that each of these concerns exists and yet is even more pronounced when the immigration courts are not involved. And another thing that I highlight are the use of multiple shadow removal proceedings. So meaning a person who is first removed from the United States via an expedited removal and then repeatedly receives reinstatement of removal orders, never has an opportunity to go before court, is barred from judicial review. And so this interaction of these different types of removals create legal sites in which the government's power is really operating at its maximum, and yet mechanisms for accountability are at a minimal level. And I've also talked about just the ways in which the unique combination of the constitutional positioning of immigration law together with the statutory framework create problems, but also might create opportunities for intervention by way of the procedural due process clause, as well as by via arbitrary and capricious review. Okay, so the fact that these highly informal agency adjudications exist is not necessarily a unique phenomenon within the larger landscape of administrative law. The ACUS, sort of breaks down administrative adjudications, as we've heard, in type A, B, and C proceedings. And as Chris Walker noted this morning, this is very much a type of type C proceeding in which maybe we don't know a whole lot and it's difficult to come to categorizations, but these shadow removals do have a place within our larger landscape of administrative law. And certainly in the immigration context, the broader immigration context, we see inquisitorial type interviews used to conduct adjudications, for example, of benefits or visas or even asylum applications all the time. But at the same time, I think there are some details worth highlighting. So what I talk about in this paper on barricading the immigration courts is in part an expansion of the use of these type C adjudications, really with the express purpose of precluding access to a type B adjudication, i.e. immigration court. We've talked about the stakes that are involved in these cases. So this is not just about making decisions over peanuts at the border. These are, actual lives. And expedited removal in particular tends to be happening oftentimes in towns at the border that are well known for fostering or not providing protection to people who are escaping particular types of violence. So to the extent that the poet Warson Shire said that no one leaves home unless home is the mouth of a shark, then in many of these cases, people are still actually residing within reach of the shark's jaws. There's a carceral setting. There are elements of race and language and class. There's our currently highly politicized nature, as well as the minimal review, and the fact that when it comes to shadow removal proceedings, at the end of the day, the legal consequences are still the same as removal orders that are fully litigated before immigration courts. One thing that I don't really talk about in this paper, but I do want to mention, and that Mike mentioned briefly, is a new program called the Migrant Protection Protocols, and in many ways they're known as MPP. What that is a program that's been set up along the border where individuals who are seeking asylum are permitted to have immigration court hearings, but during the pendency of their immigration court hearings, they are required to stay in Mexico physically. It's created a whole set of problems around physical danger, as well as actual physical access to the immigration courts, because appearing for one's immigration court hearing in the MPP context does require a certain amount of cooperation from border officials to even cross the border and get to a court hearing. So in many ways, the MPP program really turns on its head the idea that we can even find a strong distinction between immigration court proceedings and an adjudication that is something else. It's not really the focus of my work here today, but it's something that I did want to inject into the conversation. Okay, so I just want to talk a tiny bit about expedited removal because I'll just highlight a couple of pieces of expedited removal because this particular type of removal order is really important to the broader trend that I call barricading of the immigration courts that I'll highlight today. And so expedited removal throughout its history has operated at the border. It's authorized by statute and regulation. It essentially allows border officials to summarily issue removal orders against people who are apprehended at the border. It doesn't mean that every single person who lacks entry documents at the border is immediately removed. What it does is it creates sort of a multi-tiered process so that a person who is seeking asylum and is apprehended at or near the border, they need to walk through a number of steps, and should they fail at any one of these steps, their results will be this summary removal order. And so I'll highlight the two main parts of the process. One is a border interview or a border screening where the only factual question that should really be addressed is this person afraid? Or does this person express fear? It's a fairly straightforward factual question. Studies, though, around the procedural integrity of how these border interviews have been conducted have revealed some various kinds of problems, really with agency officials complying with existing agency policy. So things that we would ordinarily take for granted, right, to the extent that we talk about like the elements of procedural fairness, aside from things like, notice and an opportunity for cross-examination, most of us would take for granted sort of the right to have one's answer accurately recorded and put down on a piece of paper that does actually reflect the conversation. So that's the type of deficiency that by and large has been witnessed, and witnessed also even in the presence of international observers. One thing that immigration advocates, just by way of example, have reported on are numerous cases where toddlers have come through these border interviews and where the transcript summary, not verbatim transcript, but transcript summary of these border interviews has been, to child, why are you coming to the United States? Answer, I am here to work. So nonetheless, these interviews carry high stakes because a failure to have been recorded as articulating fear leads to the expedited removal order. And this particular piece of the process provides for very little outside review. They often take place via video conference, often will take place in the presence of other individuals, maybe with several people on a bench. Had a client who was in that situation and then asked to articulate her fear about really extensive domestic violence, including sexual violence, while sort of couched, squeezed in between two men. Nonetheless, if a person makes it beyond the border interview phase, the next phase is what's called a credible fear interview, and that takes place before a different agency official, an asylum officer employed by U.S. Citizenship and Immigration Services, where the assessment focuses on whether the person has a credible fear of returning to the United States. Credible fear interviews often occur by phone or could happen in person. Typically, a person is detained, often for quite a few weeks, before the credible interview takes place. And credible fear interviews do actually have fairly high grant rates. They're meant to be interviews in which a full-fledged asylum assessment is not intended to be made, but as I will share, that's really become sort of the pinpoint at which recent policies and agency actions have sought to expand the basis on which credible fear interviewing officers have a basis to issue more denials, and so we've seen more denials of the credible fear stage. The other thing I'll just quickly mention about credible fear is there's a very limited review of the conclusion made after a credible fear interview that can then go to an immigration judge. The immigration judge's assessment can last within a matter of minutes, or it can involve a more searching review of the statements made. But after a quick immigration judge review of this stage, there really is no further review after that. There's no right to go to federal court. There is a question pending before the Supreme Court right now in the Thurasigium case as to whether there could be habeas review of these credible fear assessments. But this area is really highly contested, and over the course of most of the history of this particular practice, again, federal court review has been extremely limited. Okay, so how am I doing on time? Okay. I'm going to really briefly mention what's actually at the bulk of the essay. And I'd like to, I think I forgot to say, I really want to thank, I really mean it, I sound redundant, but I want to thank Chris Walker and the organizers, the Duke Law Journal editors, for putting together this truly excellent symposium. I do have a short essay that explains some of the more recent moves that we've witnessed happening and that we've seen witnessed happening by way of a variety of procedural mechanisms. So everything from interim and final rulemaking to really unwritten practices to sub-regulatory agency guidance to asylum officers, as well as bureaucratic reorganization of who conducts these credible fear interviews after all. And so I'll just highlight really quickly 4 categories of agency action, most of which have been quite heavily litigated, many of which have been the subject of national, partial, then stayed injunctions. So one is metering. Metering is the process of simply telling asylum seekers at the border that they are not permitted to approach the port of entry. And so kind of more literally and quite physically blocking access to the immigration courts in that way. One thing I'll notice that in the litigation, about the first year and a half of the litigation was focused on the question of whether metering was happening at all, because the federal government's position was essentially that it was more or less an ad hoc practice that didn't really constitute an agency policy. The court ultimately found the government's arguments not that persuasive, in particular after high-level agency officials said things like, "We are metering." But you can see in the image that's sort of the level of formality of this practice literally is like a person taping up on a handwritten piece of paper. This is the number that you have, that you were previously given through this book that was administered by a Mexican immigration official. And so if you have this number, you're now permitted to approach the port of entry. And metering is part of the reason why we've seen this proliferation of tent camps and what many have characterized as a real human rights crisis in many Mexican border towns. A second category of action are the asylum bans, which have been via interim rulemaking, rules stating that certain categories of people are barred from receiving asylum, not so much based on the nature of the persecution that they've experienced, but more so on their travel patterns. There were two separate asylum bans, both of which were litigated, both of which had fairly similar procedural sort of postures in terms of the rulemaking process as well as the litigation claims, but really ended up with quite different results. And while in many ways the asylum bans are part of a broader conversation and part of a broader set of policy priorities related to the law of asylum, in many ways this focus on whether cases get to immigration court and how expedited removal is used to prevent access to immigration courts was also very much part of the agency's rationale for these bans. A third category of action is simply in the sub-regulatory guidance given to officers conducting credible fear interviews to interpret the law in ways that would lead to higher denials, as well as sort of pilot efforts to reassign Customs and Border Patrol officers instead of asylum officers to conduct the interviews themselves. And so there's a whole literature on the differing agency cultures of Border Patrol versus citizenship and immigration services that I think helps illuminate why this is a significant shift. And then finally, there's what's known as the expanded expedited removal rule. So under current under pre-rule regulation, the map and the orange shows a 100-mile slice of land that indicates areas in which the government was capable, in limited circumstances, of using expedited removal. The direct rule issued by DHS via the expanded expedited removal rule would have essentially painted the whole country orange and permitted ICE officers to summarily remove people who are not able to show that they were in the United States continuously for a period of 2 years prior to apprehension. This rule is not currently being implemented as a result of a national injunction, but certainly is a shift away from simply thinking about these various agency actions purely through the lens of asylum, but also, again, through the lens of barricading access to the immigration courts. There are a number of implications for how we think about adjudication, specifically maybe the need for more thinking around Type C adjudication, implications for thinking about how we frame our conventional understandings over the role of immigration courts versus other actors in terms of the broader adjudicatory scheme, as well as conversations about the relative role of competing principles. So to what extent is efficiency the most important principle in structuring an immigration adjudication system? To what extent do we care about things like accuracy and legitimacy, uniformity? How does judicial review shape the way in which the system plays out going forward? So I will stop there so that we have time for questions. Thank you.
Thank you all for those wonderful presentations. We have 15 minutes left for questions, so let's jump in. Isha?
Thank you all. This is so interesting. So I have a question for any one of you about kind of the underlying dynamics that are driving these types of summary proceedings. And I guess my question is, there's a sense in all of the things that you've discussed that there's something hidden about what's happening, and perhaps it's hidden given just how high the stakes are and how much these procedures deviate from what we expect to see when you're studying what, say, federal courts do, right? But I was wondering, like, to what extent do you actually think that this is hidden? Like, I mean, given that, I mean, the president's certainly been very, very open about the value in summary proceedings. In terms of the governing structure, it's very open, right, that the Attorney General has the ability to review cases and send these memos. So, I mean, maybe you disagree about the hidden aspect of it. I guess that's just one question. I mean, do you think this is actually hidden? And if so, in what way?
I mean, I guess my first reaction is I'm not sure it's all that hidden, which I think you alluded to with your question. But I also think part of, it's interesting because I feel like immigration scholars, we often, we talk about like immigration exceptionalism, and then we come into administrative law circles, and we're reminded there are various aspects of what we see witnessing in the immigration system which might not be all that exceptional and might be, right, generalizable. And yet at the same time, we do still have things like, the plenary power doctrine and the way in which constitutional norms haven't fully permeated the immigration space. And so I think maybe it's sort of a combination of both, right? Like we can look at the current political moment and the rhetoric and the narratives that seem to be dominating a lot of the public discourse around immigration, but those are then sort of come to a head against really longstanding doctrine that has prevented sort of fair, in my view, fair procedures from developing in the immigration context. So there's just a couple of just immediate reactions to your really excellent question.
I guess my response is, and I don't know that this is intentional on the part of the administration, but there are some mechanisms for policy changes that are just inherently more transparent. Those are intentional, right? When the president issues an executive order, I'm cracking down on A, B, or C, right? That is for political gain. That is going to be transparent. And whether or not you agree with the ultimate policy choice made, I think that's salutary. At least we see that it's going on. There are other mechanisms for policy changes that are inherently less transparent, such as these sort of guidance memoranda, the kind of memo that your boss sends you, right, through interoffice memorandum, that may have very substantive policy ramifications. And to the extent that those tend not to be reported in the New York Times, to the extent they are presented as merely, oh, this is just a managerial, procedural tinkering, but that is going to substantively alter the lives of X many people. Those are arguably more troubling because there is so much less accountability. I think that as scholars, it's our job to try to keep up with them, but there do seem to be kind of different tiers in terms of public transparency that do not necessarily match how consequential the policy decision is.
This is a question for Professors Kim and Semet regarding your article. So to the extent that your data actually does reflect some sort of causal issue here in terms of political influences coming from the White House influencing outcomes in custody or bond decisions, do you have any ideas for kind of mechanisms that could be put in place to help control for any of those biases, especially given what we were talking about earlier about there being laws in place to prevent kind of probing ideology in the hiring process?
I know Amy's going to
Yeah.
say something. Jump in.
I'll leave it to Catherine to address some of the normative aspects of the question. But the first part is the analysis isn't really meant to be a causal analysis, because in any of this type of analysis, we're really just doing a descriptive understanding of what the data shows. Immigration law, as these other ones are all experts in immigration law, so I'm coming to it from a more empirical perspective, but immigration law has a lot of nuance to it that you really can't necessarily control for all the various things that can influence decision making. For instance, it's very difficult to determine who is not a criminal. And obviously, whether someone's a criminal or not will impact the custody decision. So while there are attempts we made attempts to try to control for that, there's really no way, really concrete way to be able to control for those type of things. So in that respect, it's almost impossible to do any type of causal analysis. But I'll leave to Catherine to the question about maybe what things that could be done.
Sure. I mean, I think it depends. The primary claim is our findings are consistent with the view that political administration is able to influence adjudicatory outcomes in agency adjudications and immigration court specifically. What can we do to prevent that? I think that there are a few different threads to disentangle. The question is, what levers, how is the political administration influencing immigration judges? And we don't know that. We have some ideas. For example, some of the Attorney General self-referral decisions, matter of Castro-Tum, matter of AB, setting forth new substantive legal standards that all of the immigration judges now have to follow. Some of those have vastly narrowed the grounds for eligibility for asylum, for example. In our view, those are relatively more legitimate mechanisms of supervisory control because at the very least they're transparent and subject to judicial review. The more, I think, discomforting types of presidential interventions might be not just a threat of you're fired, because it is true immigration judges, while they don't have ALJ tenure protections, they do have regular civil service protections. But just what is it about a culture of an organization when you show up to work every day and you know that the boss wants this? How do you stop that from influencing your behavior? It then goes to, okay, well, it depends on how concrete the boss's desires are in terms of your performance. Are you at risk of, having cases assigned away from you? Then we might be able to legislate protections for that. Are you at risk of being reassigned to, some faraway location if you don't toe the party line? So those are some of the types of intervention, some of the types of protections we can think about that I think aren't currently talked about as much.
Michael?
Yeah, these were all great. Have you thought about kind of the enforcement side of it too? Because it seems like the enforcement priorities have changed dramatically. So something, the output from the courts could also have something to do with the enforcement, the input coming in and what the kind of prosecutors, so to speak, are bringing to the court.
My own hypothesis is actually that the influence on immigration judges is probably much greater than our data suggest, precisely because my assumption is that the ICE prosecutors are bringing in a lot more cases, a lot more sympathetic cases, to the extent that they're no longer prioritizing criminals, for example. So you would think that the cases going into the system are being skewed somewhat, and so I would have naturally expected, if immigration judges were really truly independent, to be detaining less frequently than in the past, rather than more. So I think that is something that we haven't been able to isolate, but my suspicion is that if we were able to isolate it, we might see a higher magnitude in outcomes.
And one of the reasons that you can't necessarily isolate is because the agencies don't necessarily have the same, they don't set their data up the same way. So although there's a number that connects the individual non-immigrant, ICE has their number, BRIA has their number, and the databases aren't really connected. So to be able to, it would be nice to be able to follow that through, to be able to answer the kind of questions Catherine's raising.
I add something to this. I think it's really important. It actually would be my first theory about the modality of influence on immigration judges, and I think it gets at the issue of, is anything being hidden? I don't really actually think so, because we have to remember that there is someone else in the room as the prosecutor, the ICE attorney, and their first decision is whether to bring the case at all. So I totally agree with what Catherine just said, but I think prosecutorial discretion is actually multi-layered. Even after they've brought a case, they have a lot of discretion over, do we detain this person? Even if they detain the person, when the person then makes a motion for a bond, the ICE attorneys have a lot of choice, or at least as the office they do, over how strongly do they oppose the bond. Do they tell the immigration judge, we think there should be no bond at all? That would not be nefarious for, that's exactly where prosecutorial discretion is supposed to be exercised. That might be the mode by which you get different results under the Trump administration than under the Obama administration, because the prosecutors are actually making different arguments. And it wouldn't be surprising that that would lead judges to statistically significant differences in outcomes.
I mean, and there's all kinds of like granular points along the process at which frontline ICE officers really have quite tremendous power. So two examples of that are, one, in the detention decisions. Like when we talk about detention decisions going before immigration judges, that's typically after an ICE officer has determined not to release that person. So in prior administration, speaking non-empirically, many ICE officers would simply make a discretionary decision to release. The case would never have to go before an immigration judge on the detention question. Same with the charging documents. Once an ICE officer draws up a charging document, I think the sense from advocates is that that is sort of like the final decision. There's not a ton of prosecutorial discretion on the part of lawyers who are then deciding not to move forward with them. Everything is sort of moving forward after the frontline officers are making their determinations.
Is that Kate Evans lurking under the hat in the back?
Sorry, I'm back from a bind. Motion today, so I snuck in at the end. But I don't know if you're aware that Thuraskium cert was granted today, and so I'm wondering what the panel thinks that case will provide by way of opportunity to address some of the plenary power questions, constitutional norms, and maybe to some extent provide review over wide variation in asylum standards and adjudications at a really critical initial stage. I'm trying to get my hopes up, I guess.
Mike, do you want to start with that one?
Well, only really limited. Thank you for the breaking news. Really limited comment, because I've just only teaching immigration law this semester, so I've recently been had to reread again all the late 19th century Chinese exclusion era plenary power cases. And it is interesting, actually, even then, the court actually always kept the courthouse door open a little bit, which is, I think, the fundamental issue in that case with habeas. And so I think that it will be interesting whether that remains consistent. And we have one other case actually pending that has to do with how wide the courthouse door is open regarding jurisdictional issues for the federal courts on questions of fact versus questions of law, I think is the question that they're looking at. If I will not remember the name of that case right now.
Other final thoughts on the cert grant?
So I think I'm famously bad at reading the Supreme Court tea leaves, but, Thuraskium is a habeas case. And it's interesting how the doctrines of for habeas versus procedural due process, because most immigration law scholars have focused on procedural due process. What kinds of procedural bells and whistles are you entitled to? Where Thursigium is not in that posture. That's not what's being litigated. And so I'm not sure that it's set up to resolve some of these questions that we've been talking about today about exactly what kinds of procedural protection should be allowed. I think it is going to be hugely consequential in terms of, do you get to go in federal court at all? That's my 2 cents.
Okay, well, that's a good spot to end. It's 3 o'clock. Remember, PILF auctions tonight? I'll be very, very hurt if no one bids on the dinner at my house. Thank you, everyone.
I just wanted to conclude to say that DLJ is incredibly honored to have worked with all of our scholars and authors and speakers. So thank you for putting the effort into your scholarship and coming here today. Thank you also to all of the other student editors for their help and support of me throughout this process. So just thank you again and have a great rest of your day.